So, as you know, the Bill of Rights were the first 10 amendments added to the new Constitution. They were all ratified as a bunch, and the ninth state to ratified on December 15th, 1791, which is when the Bill of Rights went into effect. The amendments have since all been ratified by the rest of the states. You know that in the debate over the Constitution, one of the arguments that the Anti-Federalists made against the new Constitution was the lack of a Bill of Rights, the lack of a list enumerating the individual liberties that Americans had, and the enumeration of limitations on government actions that might infringe those rights. So that's what the Bill of Rights is. Because it was such a sticking point in the ratification debate, Madison, who was sort of the head of the ratification process, he was the captain steering the ship of ratification along, he went out of his way to guarantee that should the Constitution be ratified, the very first thing he would do in the new Congress would be to submit a proposal for a Bill of Rights. And that's exactly what he did in 1789 when the Congress first met. He, as you'll read this week, he submitted a proposal for a Bill of Rights, and then that proposal was honed down into what we have. He actually presented 12 amendments to the Constitution. Of those, 10 were ratified together as the Bill of Rights. Of those other two, one of them was ratified relatively recently in 1992, and the other still lingers. So out of the original 12, 11 have been ratified, 10 way back in 1791, and the 11th in 1992. So let's go over those 10. The First Amendment is one that contains some of our most basic civil rights. The first and foremost, the right to practice religion or to not practice religion. There's two clauses here. The first known as the Establishment Clause, which prevents the government from establishing a state religion. Over time, this has been adjudicated to essentially prevent the government from showing any sort of favoritism to one religion over another, or to religion versus non-religion. So essentially the federal government originally, and now since the Bill of Rights has been applied to all the states, state governments cannot show a favoritism of religion versus non-religion or one religion over another. So that's the Establishment Clause. It's why state-sponsored prayer in schools is deemed unconstitutional. It was stricken from the court, or the court struck down state-sponsored school prayer in the 50s and 60s. The second part of this is the Free Exercise Clause. So just as the government cannot establish a state religion, it cannot infringe on the rights of individuals to practice their own religion as they see fit. This has also been adjudicated widely. This is why churches don't pay taxes. This is why we actually have this debate over the Religious Freedoms Act and what constitutes an infringement on someone's religion. So recent debates over this have been, for instance, can the government require, say, a Catholic-based business or a Catholic-owned business to require them to provide contraception in their health plans to their employees? This became an issue with the Affordable Care Act. So it's relevant today. This has been constantly adjudicated, as have the other parts of the First Amendment here, freedom of speech, well, what is freedom of speech? You do have freedom of speech, but you also can pay consequences for your speech. It's been ruled and famously that you do not have the freedom to yell fire in a crowded theater if there is no fire. And it has been adjudicated that if you publish lies about somebody, so this also goes with freedom of the press, which comes next. If you publish lies, you can be sued. And depending on the lies you publish and who you publish them about, the law treats different people differently. Public figures are held to a higher standard of proof, but either way, you can't just say anything you want without any consequences. Again, we'll look at how some of this has been adjudicated over time, but there's lots of case law out there about freedom of speech and freedom of the press. And then you have the freedom to peaceably assemble, but again, that's been adjudicated to mean, you can't just gather and riot anywhere. The government does have a legitimate public safety interest in limiting called the time, place, and manner of assembly. So you can get a permit to hold a rally, but the government can tell you where that rally can and cannot occur. Also, of course, you do not have the right to peaceably assemble just anywhere, because private property is not government property. And you can petition the government, so send your congressman an email. Okay, the Second Amendment, you're going to look a little more thoroughly at this in one of the online interactives, so won't go into it as much, but obviously this is one of the most contentious of amendments. People who, want to enforce stricter gun controls often say, well, this amendment was written because the founders were afraid of a standing army. They didn't plan to keep a standing army. But they did want the citizen militias to be able to arm themselves in case of attack. And so they put this in to apply to not an individual right to own weapons, but the collective right of the state militias to own and possess and bear arms. And again, I've mentioned this before, but the word guns doesn't appear in this amendment. It's about arms, and arms are not just muskets, that's not just handguns, it's all forms of weaponry. So over time, although this has been adjudicated to basically guarantee the rights of individuals to own a handgun, that is sharply different than what the amendment reads and how it was written. But we'll explore this further as well. The Third Amendment prevents the government from quartering soldiers in your home. This is definitely the least adjudicated of all the amendments. In fact, it's hard to find really any good case law at all dealing with the Third Amendment. It's put in there obviously directly because the British soldiers were quartered in the houses of the colonials, and it was a very much hated practice. So this protection was put in here, but it's never really arisen. I mean, you can find some random or some fairly low-level case law about this, but there's just very little out there. It's just never really been an issue because the government has never really tried to house soldiers in our homes. Okay, Fourth Amendment has been adjudicated as much as pretty much any amendment out there. This has to do with search warrants. What is a proper search? Who has the authority to issue search warrants? What is the probable cause needed to issue a search warrant? I mean, these there's lots and lots of case law on this, and we'll look at some of it. And obviously it changes. I mean, the Fourth Amendment looks differently today than it did, say, pre 9/11. Now they can search us at the airport. I mean, not that they couldn't before. The law itself hasn't changed, but just what we're willing to accept as a reasonable search, not to mention a reasonable seizure, changes, and it has changed, and technology changes it. Also, just something like a car. So there's a lot of case law on what can a police officer who stops you on the roadway, what can he look for, what can't he look for, when does he need a warrant to search your car, same with your home. Anyways, lots of case law out there, and hopefully you'll learn something of this through that interactive that I put on there. Okay, 5th through 8, it's really mostly dealing with the rights of those who are accused of crimes. So the 5th Amendment, there's a lot here, but basically the most relevant aspect of the 5th Amendment is that you cannot be forced to testify against yourself. You have certain rights in a court of law. For instance, once a case is adjudicated, you cannot be tried for that case again. And this also guarantees you to due process, so life, liberty, property cannot be taken away from you without due process, and due process refers to that court process, right? So if you're accused of a crime, you have the right to defend yourself, and only through a proper conviction can your life, liberty, or property be taken from you. Again, the 6th Amendment dealing with criminal prosecutions, you have the right to a speedy trial, you have a right to an impartial jury, you have a right to hear the charges against you called out in open court. People who are accusing you of a crime, you have a right to see them face to face, and you have a right to counsel. And this is one of the most important aspects of modern law, is you have a right to counsel even if you can't afford it. And that's actually a really interesting case, and we'll look at that later in the year, how that right to counsel comes about. 7th Amendment basically gives you right to a jury, which we take for granted. And most of the rest of the world, juries have sort of been done away with. It's sort of seen as arcane, and a lot of legal systems around the world leave it up to a judge, which you can waive your right to a trial by jury and have a bench trial. And a bench trial is where the judge passes, the judge rules on both law and facts in the case. And it's usually, a lawyer is going to decide, okay, we're going to do better with the jury, or we're going to do better with the bench. It depends on the context of the case. 8th Amendment forbids cruel and unusual punishment, excessive bail. This has been debated a lot over the death penalty. Does the death penalty qualify as cruel and unusual punishment? Obviously, we have laws against torture, so lots of case law dealing with this one as well. The 9th Amendment, we've talked about this. It essentially reserves rights not enumerated in the Constitution to the people. They didn't want the Bill of Rights to be seen as like a comprehensive list, and so here's all the rights you have as a citizen. So if it's not on the list, you don't have the right. In fact, the discussion for this section asks you to discuss rights that you do have that are not listed in the Bill of Rights, and hopefully you'll think of a few, because there is quite a few. And then finally, the 10th Amendment. This is often called the States' Rights Amendment. It's similar to the 9th. It reserves powers and states from federal action. So if a power is not delegated to the United States by the Constitution or prohibited by it to the states, it's reserved to the states or to the people. So that is a very quick tour through the Bill of Rights. I hope that was a little helpful. And as I said, we'll see how some of these amendments have been adjudicated over time.